so simple.
Hey YouTube, Attorney Erik Hawkins back again to answer all of your California family law questions. Today we're going to be talking about domestic violence restraining orders, what they are and how you can get one. The first thing that we need to discuss is who can get a domestic violence restraining order. Well, it's very simple. Pretty much you can get a restraining order against anybody that is in your family, whether that is by marriage or by blood, any spouse or former spouse, any cohabitant or former cohabitant, and that is defined by the law as as somebody who resides in the home regularly. Also, anybody with whom you've had a dating relationship, whether it's current or in the past, or anybody who you've had a child with. Those are the people that you can get a restraining order against. Anybody who's not on that list, you can still get a restraining order against them. However, that is considered a civil matter, and so you'd have to go through the civil courts to get that. Okay, so back to family law. You want to get a restraining order because you are either being abused physically or mentally, you've been injured, harassed, stalked, or the other party has done anything to disturb your emotional well-being. Yes, that's actually part of the legal definition. It's called disturbing the peace, and case law has defined that as pretty much anything that disrupts your peace of mind. Obviously, if you want the court to grant a restraining order for such disturbance, it must be fairly egregious or repetitive, something that is perhaps a nuisance and ongoing. Those are the types of things that you want the court to step in and put an end to. So in California, and for me personally, I practice in Fresno. It may be a little bit different where you are, but there are various forms which the court provides, and they ask that you fill out to apply for a restraining order. Now, these forms, and perhaps this is just for me because as an attorney here in Fresno, we are required to file all of our forms online electronically. And if they are not filed exactly how the court requests them or in the exact order that the court wants them, the court will not accept them. Here in Fresno, people who are not represented by attorneys may file their papers in person, and so they probably don't run into this problem as much. But I have only filed a few of these and recently had one rejected because it was not in the proper order. I was able to talk to the clerk, and the clerk gave me the exact order that they want these in every time. So I'm going to share that information with you today and go over some of the forms and how to fill them out. Let me also just point out that while we're getting started here, to file for a domestic violence restraining order in California, there is no filing fee. Okay, so to file for the restraining order, there are a lot of papers. Do not get overwhelmed and do not get frustrated because you will see that they are very repetitive. You're going to be filling out the same information many times, but just go with the flow and go in this order. Okay, so these forms can all be found online, and what I typically do is I just Google, for example, the first form is called DV, as in domestic violence, DV 109. So if you pull up Google and just put in DV 109, typically the first thing that pops up will be something from courts.ca. Now that is a reputable source, as it is the California court source, and if you click on that, and if it is the DV 109 form, that will take you straight to a PDF fillable form, which is great because then you just go through and enter your information and click all the boxes, and then you can print it when you're all done, and it is perfectly clean, perfectly acceptable. It looks great. A lot of the domestic violence forms that get turned into the court are handwritten, and that is perfectly acceptable. However, try to put yourself in the shoes of the judge that's going to be reading this form. Does this look neat? Does this look well put together, well thought out? Is it something that should be taken seriously? For me, I have terrible handwriting, And so I prefer to type everything because it's so much cleaner, and the judge isn't going to have to waste any time trying to figure out what I'm asking for. It will all be clearly laid out in front of them. Okay, so if you don't want to go any further with us, let me just give you the forms and which order they need to be attached in. All of these forms are going to get filed together, and it starts with DV-109, DV-110, DV-140, then DV-145, DV-100, DV-105, DV-108. All right, there's one other form that you're going to file with that. It's called a CLETS 001, and that is spelled CLETS 001. That will get turned in at the same time as all the other forms, but it will not be attached to them. Once you have filled those forms out, you're going to want to take them down to the courthouse to file them. However, you're also going to want to take at least 2 duplicates of each form. So fill it out once, make 2 copies, take it down to the courthouse. When that other person gets served with their papers, you're also going to have to include a DV-120. That is a response to your request, and you will serve it as a blank paper, basically. You're going to print it up off the internet and just serve it to them as is. That gives the other party a chance to respond to your request, and of course they will be the one to fill out that form. All right, guys, this is the DV-109. I printed this front and back just because I'm trying to save some ink and some paper here, because there are a lot of forms. If you're doing this yourself, just do it one-sided. It'll make your life easier, especially if you're writing by hand. That way the ink doesn't bleed through. But important to note, on the DV-109, you're only going to fill out the number 1 and number 2. Other than that, the court fills out the rest. So that's a really easy one. So 109 goes on top. Next up is 110. So far, the numbers seem to be going in order, and that's great because that makes sense. 110 is much longer than 109, and here, luckily, you're only going to fill out 3 things. You're also going to do number 1 and number 2, but you're also going to do number 3. And in here, you're going to want to make sure you fill out this empty box, which talks about, pretty much describes the physical characteristics of the person who you're requesting protection against. Also, I'll show you this on another form, but you're going to want to leave this top blank always, top box always blank. Second one, you're going to want to put the county which you reside in, the name of the courthouse, and the address of the courthouse. The case number will be assigned to you when you file this, so you won't put anything in there. If you already have a family law case, say you're going through a divorce, you can put your family law case number in there, as this will be filed under that same case number. Okay, so after you've completed your 110, you're going to fill out DV-140, DV-140. 140 is nice because right up here at the top, it asks you what you're attaching this form to. So you're going to check the box that says DV-110. Okay, guys, now that you've done the 110, you're going to fill out DV-140, which has to do with child custody and visitation. The nice thing about DV-140 is right up here at the top, it's going to ask you what you're attaching this form to, and of course you're going to check DV-110. That's nice. It creates kind of a way for you to check yourself, make sure things are going in the proper order. On this, it gets a little hairy. It asks for child visitation schedule, things like that. If you have recently been abused by the other party who is a parent to your children, what we typically do is, instead of going through and filling all that out, there is a space for you to state number 3, other visitation. And what we put is number 4, you would check that box. Number 4A, you're going to check no visitation to, and then check the other party. And then we go down, check number 3, other visitation, and it tells you how to attach a sheet. And on that sheet, all we write is no visitation pending the hearing. Typically, once you file these papers, a hearing will be set 21 days out, so 3 weeks out. Can be up to 25, but 3 weeks is a fair time to keep the children away from the abusive party. And in that, you're protecting them. So you want to act in the best interest of your children, and that's the best way to do it. Because once you go to the court date, then the court can make more permanent orders. And they can also order the abusing party to get help and counseling. And so until that stuff takes place, you want to make sure that the children are kept safe. Once you're done with the DV-140, you move on to DV-145. Again, they've made it helpful, and it states that you need to attach this to the 140. So if only it were all that simple. But this one absolutely is, and I'm appreciative of that. Other than that, this one's pretty self-explanatory. This is no travel with the children. What we typically do, and you know what, we also do this on the 140. There's a spot that talks about travel with the children. It's number 7. And what we typically do is say no travel outside of the United States, outside of California, and then outside of your county without your written permission. Usually you have to fill in your county. The rest are usually just boxes that you can check. Okay, so now we are at the request for a domestic violence restraining order. This is DV-100. You might think that that goes first. It does not. All right, so make sure you follow this order. This one is much longer and has a lot more to fill out than the others, but it's basically a culmination of all the other forms into one. So, like I said, this stuff does get repetitive, but it doesn't mean that you shouldn't fill it out. Up here, obviously, you're going to keep that blank. Name of your county, name of the court, address of the court, and case number. You might recognize this. Again, they want the physical characteristics of the person who's being restrained. You do not just have to get this for yourself. You can list the names of your children or family members. And number 3, people who you feel are in danger and need to be protected. You will, later on in this form, have to explain why you feel they are in danger and why they need protection. Okay, so also part of this, you're going to want to take a look at number 6 and number 7. Those are very important. Those are kind of the heart of this order. So we always check box 6, 6A, and 6B. 7, check the stay away order if you fear for your safety, if you feel like you're in danger of physical harm. It's going to ask how far away you want that person to stay from you. We typically put 100 yards. That's the most that a court's going to give you. I've seen it for 30 yards. If you think about it, that's 90 feet. That's still a good distance. So just don't get too crazy with it. It is in yards, so 100 is always a pretty safe bet. The next one, number 8, is a move-out order. This one's huge if you are living with the abuser, and especially if you have children. You don't want that person around you. You don't want them around the children. If it's just you, you might have a place where you can go to get away from the abuse. But it's a little different when you have to relocate your whole family minus the abuser. So you can ask the court to tell the abuser to get out of the house. What do they have to do to qualify for this? Well, the court limits this to people who have committed assault or who have inflicted physical or emotional injury. So that's pretty broad, and most abusers fall into one of those categories. Assault means somebody who has threatened you with violence, and that violence is imminent. They're going to do it now. They're going to do it soon, and it's something that they feasibly could do and can act upon. So a valid threat, an imminent threat, those are assaults. A threat alone is not an assault, but if somebody has the power to go through and follow through with that threat, then it becomes an assault. So if your husband is the abuser and he's much larger, much stronger, and has a short temper, and he says he's going to knock your lights out, that can classify as an assault and not just a mere threat. Number 12, if you have a visitation order, let the court know. If you don't, this is a great way to get one. Same thing with child support. Oh, and one other note on that form, number 17, spousal support. If you are married to the abuser, or in the rare case that you are in a registered domestic partnership, and you would know if you were, because you literally have to register with the Secretary of State. But more commonly, if you are married to that person, you may ask for spousal support. If you were not married to that person, and you do have children, but you just live together, you're not going to get spousal support. So it's not worth checking. Lastly, on this form, number 27 asks you to describe past incidents of abuse. It gives you only a few lines. If you look right below those lines, it tells you what to do to get more space. And realistically, if you have been abused and it's not the first time, there probably have been more than one time. What you're going to want to do is take advantage of the extra space. You're going to, on that separate page, you're going to title it DV 100 Recent Abuse. Under that, you're going to want to state what you're asking the court to do. Because it is a separate paper, you just want that always before the court. Then you're going to go chronologically with the most recent incident of abuse, and you're going to go back in time listing each and every incident of abuse. The more recent the abuse is, the more powerful it is in the eyes of the court. You know, if the abuse was 10 years old, not as pressing. However, it does show that the abuser does have a propensity for violence. So you may want to list it, you may not. The court typically does not consider abuse that is older than 5 years old, but I have seen abuse considered that was over 10 years old. So it may be worth listing. What I would recommend is that you keep it succinct, meaning you get your point across, you state exactly what happened, but don't go off track. Don't go into unnecessary details. These are a lot of papers for one judge to review. Make sure you get your point across, but do it quickly. It's more powerful that way. It doesn't muddle the message. All right, next we have DV 105. DV 105, again, child custody, visitation orders. On this, I believe you can check no custody or no visitation pending the hearing. Next, DV 108 is no travel. Again, you're going to want to put no travel outside the country, outside the state, or outside the county. And now we have the cleats form. This is filed by itself. It's given to the court. It's rather thorough, and it is basically the physical description of the person that's going to be restrained, but it also provides other information such as their place of residence, their place of business, and it asks for their driver's license number, social security number. So this is really a tool for law enforcement more than the court, which is why it is turned in separately, but at the same time as the domestic violence packet. Now, remember the order that I told you, all of those get filed together as one document. This gets filed at the same time as a single sheet of paper, but its own document. All right? If the other person has a gun, once a restraining order is granted, they can no longer be in possession of that firearm. So you're going to want to serve them with a DV 800, which requires them to record the fact that they have turned over their firearm to either a licensed gun dealer or local law enforcement. Also, remember to serve them with a blank DV 120, and that's about it. It sounds complicated. It is complicated, and they are very finicky about how it's done. They want it done in the right order. But it is a great tool to protect yourself and your loved ones. It is very important that you do it correctly, but it is very worth it. So take the time, do it right. Once you've filled it all out, you're going to be at the courthouse anyway. Go over to the self-help center. Ask them to review your paperwork. This may be a little frustrating if they find problems with the paperwork, but it's better than taking it to the clerk and having the clerk not accept it. So they will do that for free. You can file for free. Serving the other party, ask the clerk how to get the sheriff to serve the other party for free. The state is very interested in protecting you and protecting your children, and so they make this as easy as possible, aside from the forms. But even though the forms are repetitive, they're not too complicated. A lot of boxes to check, but they're very straightforward. They've done a very good job of simplifying these things. All right, so that does it for this video. If you have questions or comments, please leave them below. We will try our best to get back to you. Remember, this is California specific. If you have more questions for us that are not pertaining to the DVRO or Domestic Violence Restraining Order, go to our website, hawkinslawfresno.com, and submit a question. And then make sure you subscribe here on YouTube, because your question may be the one that we answer next.